Welcome to Video 3 of XT 1777, focusing on the Mine Health and Safety Act and its legal liability aspects. This video was created in August 2025. Regarding risk assessment, every employer must identify hazards, assess the risks, record the significant hazards and risks, and make those records available for employee inspection. Employers must also consult the Health and Safety Committee to determine measures to eliminate, control, or minimize risks. Where risk remains, they must provide PPE and institute a monitoring program. Every employer must implement these risk measures, as far as reasonably practicable, in the specified order. They must also periodically review the assessed risks and consult the Health and Safety Committee on the review. Employers must conduct investigations into reportable accidents, serious illnesses, and health-threatening occurrences. They must consult and cooperate with the Health and Safety Committee and representatives during these investigations. Upon completion of each investigation, a report must be prepared. This report should identify causes, underlying causes, unsafe conditions, acts, or procedures, and include recommendations for prevention. A copy of this report must be delivered to the Health and Safety Committee or representative. An employer's investigation may be held jointly with one conducted by an inspector. If there is no Health and Safety Committee, consultations must be held with health and safety representatives, or with the employees if there is no representative. Risk assessment is a key step in risk management, determining the quantitative or qualitative value of risk related to a threat or hazard. Employers must prepare an action plan for risk elimination or control to meet their responsibilities for worker safety and health. The action plan should cover commissioning and coordinating the assessment, appointing competent assessors, consulting worker representatives, and providing necessary information, training, resources, and support to the assessors. Worker participation in risk assessment is crucial. Their practical knowledge of tasks and problems is valuable for developing workable preventative measures, making occupational health and safety management effective and efficient. Workers and their representatives have the right and duty to be consulted on risk assessment arrangements, participate in the assessment, alert supervisors to risks, report changes, and be informed of risks and necessary reduction measures. They should also be involved in deciding on protective measures. Those carrying out risk assessments should have knowledge of hazards and risks, materials and equipment used, working procedures, exposure types, and relevant legal standards. This includes modern, validated measurement techniques when appropriate. Employers must ensure that assessors speak to employees or contractors carrying out the work. If employees from different employers work together, assessors may need to share information about risks and safety measures. Baseline assessments, required by Section 11.1c, involve developing a company-wide profile of significant hazards. This serves as a snapshot of the hazard profile and is a starting point for permanent risk elimination, including a priority table based on the likelihood and criticality of identified hazards. Issue-based assessments, required by Sections 11.2, A and B, are detailed assessments of elements within the baseline profile. Primary examples include failure mode and effects analysis, failure mode and effects criticality analysis, and event tree analysis. As circumstances change, separate risk assessment studies are needed as part of managing change. This occurs when a new machine is introduced, work systems or operations change, or after an accident or near miss. Section 11.2 mandates continuous assessments to control, minimize, or eliminate identified hazards. This requires employers to set up a program of continuous assessments, including general, pre-use, pre-work, and planned job observations. Risk control, per Section 11, has 3 stages. The pre-contact stage involves proactive systems aimed at eliminating accident causes before a loss occurs. The contact stage aims to reduce the number of consequences to an acceptable level. Post-contact control measures like emergency preparedness mitigate the size of the loss if initial measures fail. Regarding occupational hygiene, the employer must engage qualified personnel to measure hazard exposure levels if required by regulation or if a risk assessment determines it is necessary. Occupational hygiene measurement systems must be appropriate for the hazards and designed to provide information for eliminating, controlling, and minimizing employee health risks and hazards. The employer must keep records of all occupational hygiene measurements, linked to each employee's medical surveillance record as far as practicable. This system must be linked with the risk assessment program. Section 12.2b requires quantitative assessments of potential hazards. The methodology must identify and prioritize hazards, determine control measure adequacy, and establish an action plan for implementation and follow-up. Periodic review is also required. Employers must establish and maintain a system of medical surveillance for employees exposed to health hazards, either by regulation or as determined by risk assessment. Medical surveillance systems must be appropriate for the hazards and designed to provide information for eliminating risks, preventing occupational diseases, and include initial and periodic medical examinations. Employers must engage the services of an occupational medical practitioner or other qualified practitioners as necessary and supply them with the means to perform their functions. A medical surveillance record must be kept for each exposed employee. If an occupational medical practitioner is unavailable, a medical practitioner may be engaged temporarily. The occupational medical practitioner must promote employee health and safety and assist with occupational medicine matters. If an employee is declared permanently unfit due to occupational disease, an investigation must be conducted. For temporary unfitness with expected recovery, the occupational medical practitioner must notify both the employer and the employee. Records of hygiene measurements, medical surveillance, and instruction are to be retained until the mine closes, at which point they must be delivered to the medical inspector. The surveillance system must be linked to the findings of the occupational hygiene and risk assessment programs. It must also have a site-specific orientation, exceeding the scope of compensatable health hazards defined by ODIMWA. Pre-employment and periodic medical examinations are now mandatory under the Mine Health and Safety Act, including for all full-time, casual, and contract employees. An occupational medical practitioner conducts the surveillance, maintaining health records dating back to the employee's start date at the mine. The goal is to detect health deterioration since the last examination. If deterioration is found, the practitioner must notify the employer, as this may signal a workplace health hazard requiring assessment. The examination also confirms the employee's fitness for their job. If an employee is no longer fit for their job, the practitioner must record this as an incident and report it to the Department of Minerals and Energy. Section 14 requires the employer to maintain a service record for employees undergoing medical surveillance and provide copies to the medical inspector when an employee leaves or upon the chief inspector's request. Under Section 15, medical surveillance records must be kept confidential, only disclosed if permitted by medical ethics, with the person's consent, or by a court order. Section 17 mandates an exit medical examination for employees subject to medical surveillance when their employment terminates. This must occur before or as soon as possible after termination, and the employee must attend. The occupational medical practitioner must produce an exit certificate showing surveillance results and occupational disease presence, and include a copy in the employee's medical record. Note that Section 17 was amended to only require exit medical certificates for employees who are required to undergo surveillance for medical exposures. Regarding costs, Section 18 requires the employer to pay for all clinical examinations and medical tests performed under the Act, unless explicitly stated otherwise in the Act. Section 19 grants employees the right to request and receive copies of their medical surveillance records kept under Sections 12(3) and 13(3)(c). Additionally, the occupational medical practitioner must provide the employee with a copy of the exit certificate following an examination under Section 17. Section 20 allows an employee to appeal to the medical inspector against a finding of unfitness for work or any finding in an exit certificate. Appeals must be lodged within 30 days and state the grounds. The medical inspector will arrange a re-examination by an independent practitioner, paid for by the Chief Inspector of Mines. The medical inspector reviews the appeal and the new medical report, then confirms, sets aside, or varies the original decision. Employees retain the right to seek other medical opinions or pursue legal remedies.